If you haven't followed the podcast yet and don't know who I am Chris Wright, the head of PUBS Advisory Service here in the UK. I provide insights into the UK pubs trade, speak with other experts, share experiences and stories from publicans across the country. Along the way, exploring different pubs, how they are run, and speaking with the operators. Podcasts are released weekly, and we are always interested in what our audience has to say about pubs as well. Take note, you can take part as well. So how do you contribute to the Our Pubs Speak Out podcast? You can WhatsApp us on 07766 07 3815. Leave your story in the form of a voice message or voice note. 5 mins is approximately the maximum time length. If you're cut off or have a longer story, message back and continue where you left off. Please include as much detail about your experience as possible and avoid recording in noisy places or a moving vehicle. I recommend subscribing to the Pubs Advisory Service. It's the most extensive pub service offering more than just representation. We have online calculators, document banks and other resources for those interested in running a pub business. You can claim all of the costs of subscribing back as a business expense. Some of the WhatsApp content will make it into special episodes of my podcast, exclusive only to subscribers of Pubs Advisory Service. A paid-for subscription gives you early access to episodes, plus online Q&As where I answer listeners' questions about the industry.
If you're not a tenant of a pubco, then the license might be held by you as the owner-operator or by your company. Different operators may have different preferences as to whether the license is held by a holding company or whether it's held by the actual operational company. And that really is a question of preference, I think. There's not really a point of law on it, though you can take and explain the differences, but at the end of the day, I think it comes down to what is personal preference. And then obviously there'll be sole traders who may have the license themselves or hold it with a business partner. In addition to that, you may also come across a phrase called shadow licenses, which are becoming more frequent. And there'll be licenses which, in cases where you've got a landlord who doesn't normally hold the license for the premises, they may get a premises license to protect their interest in the property, so that if a tenant does something wrong, causes a problem with the premises, or if the tenant leaves and tries to hold the license to ransom, then that protects the interest of the landlord, and they're able to say, well, hey, that's okay, we've got our own license, you go and do whatever you want to, but we'll operate with ours.
Yeah, is that because, this sort of trend perhaps of commercial landlords holding the license, is that because it's expensive to replace a license if it gets lost?
Certainly can be. In certain cities, certain towns, if there's a restrictive policy that the local authority have in relation to licenses, then it can be difficult, very difficult to replace a license if it's lost through a revocation or through a company going into liquidation, but the appropriate safeguards aren't put in place and the license just lapses. So yes, it's about protecting that asset, really.
Yeah, understood. So on the subject of DPSs, a minimum of 1, but is there sometimes a requirement to have more than 1 for certain venues if they're really big or they operate in different areas?
Cool, Chris, you're taking me right back to the beginning of this Licensing Act in 2003 now.
Dust it off.
My view always was that there's nothing in the Act which limits the number of DPSs. However, whilst I have that view, it may be that I'm in a minority. Certainly, local authorities are of the view that you can only have 1 DPS and would never agree or countenance or even think of anything more than just 1. So I would have said that given the practice of all local authorities in England or Wales that I've come across, it would only be 1 DPS. That can, I suppose, cause some difficulties if the DPS leaves quickly. And it's not unknown if you've fallen out with your DPS for the DPS to give their notice in or send notice to the police on a Friday evening of a bank holiday, to try and cause as much pain as possible to the owner operator.
Okay.
So that's certainly a possibility, but there are ways around that. If you're able to move quickly, and if you hold the license, of course, you can put an application in online, and most things should be able to be in place to enable you to operate. And most local authorities are understanding in those circumstances. Not all, but most are.
So it's a good idea to know where that web page is, because if you're in a bit of a hurry on a Friday evening, you want to know exactly how to get to it.
I'd probably put it this way, Chris. I think it's a good reason to know either a good licensing consultant or a good licensing solicitor, so that they can get you out of those holes that you're in.
Indeed.
There we go. I'm bound to say that, aren't I?
Well, indeed. I know we'll put your details up for everybody. I mean, at Keystone, there are you open office hours, or do you do emergency cover as well?
I've acted for a long time for the nighttime industry. Some of my clients operate through the night. Some of them operate in the sort of adult entertainment areas as well. So my practice has always been that because my clients are open during the night, then I seek to be available when they need me. So that does include being available
Around the clock.
Around the clock, yes.
Fantastic. Oh, that's good to know. Just with regards to the registration of DPSs and license holders, you mentioned something to me at a meeting the other week. We was at the Kent LVA together, which was a wonderful organisation. Any publicans in Kent should join the Kent LVA.
Absolutely.
And myself and Robert are often there. Robert, you mentioned about mistakes with regards to updating addresses, and this was causing problems. Licenses were being lost or lapsed or fines. What was happening there? Just run us through that.
So this crops up on a number of occasions. Sometimes, as these things do, it can crop up when something has gone wrong and there's a problem. And instead of it being then straightforward to deal with that problem, you then find that there's another problem which is caused because an address hasn't been updated, or contact details haven't been updated. So it's important to make sure that wherever possible, those details are accurate and correct. So it can also arise in relation to the payment of annual fees. Some local authorities, again, not all, will issue reminders or invoices. But if the details of the license holder or where they're sending it have not been updated, then they may send it to the wrong place, and therefore you don't get the appropriate notice. That can cause difficulties down the line if the annual fee is not paid, and there's then threats or actions are taken in relation to suspension of licenses. So it's just very, very important to keep those details up to date. The other one, which is also a common one, which I come across very frequently, is on personal licenses. Many people may have got their personal license back when the Act was passed. So back in 2005, when the Act came into force, may have had the license now for 20 years, and possibly may have forgotten what is even in the license, may have misplaced it. That's another issue, but certainly the details may have changed. And it's important to make sure that those details are correct, because if you rely upon those details when you put an application in, if the local authorities see that those details are not correct, some local authorities, again, may be awkward and may say, well, we're not going to process it, or we're not going to deal with it because you haven't got an up-to-date premises license, personal license. And that just creates an added complication, difficulty that you have to get through, which you might not be looking to get, to deal with at that particular moment.
And I mean, undoubtedly, from this one of the reasons I got you on this podcast, your expertise about all these hurdles. But the thing I'm getting the flavour of licensing across the country is these hurdles are different shapes and sizes, and not all local authorities play with the same set of hurdles. So experiences vary widely.
Yes.
That's clear, absolutely clear. I think as you touch upon, some local authorities take a very stiff view, very fixed, focused about it, and others they've got a bit more latitude and leeway,
Mm.
and the Licensing Act allows them to behave in that way. Is that's correct to say? Is it they do have this sort of leeway and latitude, or
um, I think there's some grey areas and greyness that
fine?
some local authorities are prepared to allow, and others are not. I think that if you were looking at the principles, some of the key principles behind the Licensing Act are often to do with collaboration and collaboration, between the authorities and between operators. And I think if you've got a good relationship with either the licensing police or with the licensing officer, then that helps. And there can be that can just help sort of smooth things and facilitate difficult situations when they arise.
So just give me a recommend. Would it be recommended that a new operator coming into the trade for the first time, taking on their first pub, here they are opening up their pub bar in Canterbury. Do you think they should reach out to licensing straight away? Do you think they should begin that relationship early, just so they know they're on the straight and narrow? Would you recommend that?
I think it's important to have a good relationship with your licensing officer. If there's a noise officer that operates in the town, and also if there's a police licensing officer, I think they're sort of the key people. And preference, I suppose, would be your police licensing officer and your licensing officer. Having a good relationship with them can often mean the difference between a problem which becomes insurmountable and something which people are prepared to work through, if they know you, if they trust you. Licensing, and I say this a lot, and so those who've heard me say it, please forgive me. Licensing at the end of the day is a lot about trust, and trust is sometimes helped by actually knowing the people that you're dealing with.
That's a very, very, very good comment. Just an absolute newbie question. I'll chuck it in here about DPS. Let's say you've taken over the pub. You're a very small unit, maybe a husband and wife and one other full-time member of staff. One of you's the DPS. You go down the cash and carry. Are you allowed to do that while the pub's open? Can you leave the premises?
Very good question. And certainly, going back again to when the Act came in, there were a number of articles and a number of police forces, I think, and licensing authorities that would be against the DPS leaving the premises when it's open.
Right.
There's no legal requirement for the DPS to be present.
Mm-hmm.
And they can delegate authority to other individuals. It's important for the DPS's benefit that they ensure that anyone they delegate down to, and particularly the delegation of the authority to sell alcohol, that those people are trained, they know what they're doing. Because if something goes wrong, person sells to someone who's underage, or something happens at the premises and the staff are found wanting, then the people that the local authority will look to, or the police will look to, will be firstly DPS and secondly license holder, and they're going to be the key people that they hold to account on it. So it's important that if you are delegating authority, and there's nothing says that you can't, everything says that you should, then just be responsible about it. Make sure that you've got proper records, training records. Make sure that you've got a proper record of the delegation. It doesn't have to be in writing, but it's much better if it is. And you've got some acknowledgement from the individual that you have given them appropriate training and they feel confident with the role that they're being given.
Sure. Oh, that's brilliant. Thank you, Rob. That's very well put. Let's move on. So I've loosely called this residential clashes. This is the area where people perhaps who don't drink in the pub, maybe your neighbours, maybe other business people around you, they come into some conflict with you ostensibly that could be noise, it could be where the bins are sited, it could be a manner of things. In your experience, the residential clashes, what commonly are they, and how best to mitigate from having clashes, with other residents? What's your view on this?
Most often, I would have said clashes relate to noise, either noise escape from the premises itself or caused by patrons outside, either in some form of garden or outside smoking. Sometimes you'll get dispersal issues at the end of nights, but the main issues I would have said are to do with noise, and that uh, again, it's one of those things. I would say it's important wherever possible to maintain a good relationship with your neighbours where that is possible. And that's important because if the neighbours feel that you're creating a nuisance, then of course, if they say, well, this is a public nuisance, you're not promoting that licensing objective, they can encourage the licensing authority to bring a review against you, the environmental health team to bring a review, or they could bring a review themselves. And from my experience in dealing with these things, the licensing authority, when they come to deal with it in committee, will look at your relationship with the neighbours, will look how you've responded to complaints over a period of time, will look at whether the neighbours in fact have brought their concerns to your attention.
Sure.
But the key is, how do you respond to that situation when they do? And it's important that you respond to those issues in a positive way.
Yeah, don't let them
wherever that's
fester.
possible.
So
Yeah.
it's important to keep a log, records. What would you suggest? Record? Can you do digital, paper? What would you prefer? What do you think's more?
Being a typical lawyer, of course, documentation and keeping records is vital, very bureaucratic. And the reason for that is that if you're in a review hearing, if you say you're doing something, people may or may not believe you. If you say you're doing it and then produce a record which demonstrates that you're doing it, vast majority of times, the authorities will believe what you're saying. And that sounds it sounds trite, but I think actually is very, very true from experience. So yes, keep records. If you have meetings with residents, then keep a record of who attends, roughly what's said. If you're a great note taker, that's wonderful. If you're not, then maybe if you have a link either with a WhatsApp or with an email, then I'd suggest that you drop an email to persons who've attended, just to say, hey, thanks for coming. This is what we've discussed. Hopefully you found that helpful. This is what I'm going to do.
Sure.
Following on from that. The other key thing, though, if you do keep records, is that if you say you're going to do something, it is vitally important that you do it. There's nothing worse than saying you're going to do something and then you don't do it because you're seen to be unreliable.
Sure.
Local authorities will start to look at you with a little bit more suspicion about, whether you're being truly genuine with them as well. So
if you're going to make a promise, keep the promise.
absolutely.
Right there, absolutely. With regards to these residential clashes, as we loosely title them, in your experience, doing nothing isn't an option, as you described. You can expose yourself, but do you find that the majority of these things peter out within a period of time, or do they fester away and they build up over years? I mean, the flavour of an awkward neighbour, is it a long-term strategy that the publican or the bar owner has to face? Was that fair to say?
It can be. You're talking to one of the lawyers who dealt with the famous case from Soho, called Hope and Glory, and that all dealt with a neighbour opposite a small London pub, and a lot of people outside drinking, and that ultimately ended up in the Court of Appeal. So yes, if you don't get it right, certainly things like that can happen. I've also acted for the Royal Albert Hall, and surprisingly, they also had issues with neighbours, wrongly, may I say, back in the early 2000s, and that also ended up in the Court of Appeal. So there we go.
Wow. Yes.
That's how important it is.
Yeah, indeed. Well, that dovetails neatly into this other issue, which is, as we said, residential clashes, but residents you haven't even met yet. And this is the agents of change issue, where residential developments and other types of development are happening in town centres, sometimes at a rapid pace. And this is clashing with a pre-existing business. So here you are, your pub bar, and suddenly someone's building 60 flats next door. You haven't even met any of these residents, but what are people trying to achieve there? They're trying to achieve some sort of marker to stop any residents complaining. Is that how the system's meant to be working, or what's your experience of that?
It's very difficult, I think, in this country, in these scenarios, because we don't have any concept of coming to the nuisance, as it were. So the fact that the pub may have been there for 100 years or so is irrelevant. So it's important, if you can get involved in the decision-making process, if you're able to get involved in that, if there's any applications for planning permission, I would suggest that you try and get involved in those, because that can be helpful. It can get you recognised as a business operator there, and it may be that something can be done in relation to in relation to the planning, or it may be that something can be done in relation to the developer. If we're talking about a development which is already there and it's in the process of being constructed and people are even in the process of moving in, I do think that wherever possible, it's important to try and maintain a good relationship, open relationship, in communication with your neighbours. If you've got a late night operation and you think that that may cause some difficulties, again, I would suggest, if at all possible, approach them and actually, try and start a dialogue with the neighbours, so that if there are issues, individuals are more likely to come to you to try and resolve it than go to the authority.
Sure.
And if they go to the authorities, then depending on which authorities they go to, it could just mean that you're more under the microscope. They're paying particular attention to how people stand outside and smoke, the numbers of people outside, the type of noise that may be created, what's happening at dispersal times. All of those things can be issues which, if are looked at very closely by the authorities, you may find that your systems are not as strong as you thought they were.
Are you a publican navigating the choppy waters in the UK pub industry, or perhaps you're looking to get into the trade for the first time? The Pubs Advisory Service is here to help. We provide essential advice and support, from licensing and legal queries to tenancy agreements and business growth strategies. Want to unlock exclusive insights, in-depth guides, and all our past podcast episodes, including hidden extras? Subscribe to PASS today. Membership gives you unparalleled access to expert advice, ensuring your pub thrives. Visit pubs.expert to learn more and subscribe. Don't miss out. Empower your pub business with Pubs Advisory Service.
The actual format of a license is actually set by Parliament. And so there are two main parts to your license. There's a Part A and a Part B. Most license holders will have, or will know, that the Part B, known as the premises license summary, is the bit that they'll display either in the bar or somewhere where people can see it on their premises. So that's the Part B. That sets out the name of the premises, sets out the key licensable activities that you can carry on, gives you the times when those licensable activities can take place. We'll say whether it's an on and off or on or off sales in relation to alcohol. We'll have who the DPS is, and we'll say whether access to the premises by children is restricted or prohibited. Usually it's about 1 or 2 pages. Some local authorities have them at several pages long. It just, I suppose, depends on how many licensable
Do you
activities
have
you
to
have.
buy a bigger picture frame to put that up in your bar?
You probably need to buy several picture frames.
So, fair enough.
um,
So it has to
I,
be visible, easy access, easy displayed. Somebody,
yes,
yeah.
there are some. Again, this will depend on the authority. All of the summary should be on display. Some authorities, and it may be people who are listening to your podcast may say, "Well, hang about. I don't have to display all of mine. I just put one. I just put the front page visible in an A4 frame, and everything else is behind it." And some authorities are relaxed and probably won't bat an eyelid at that, and will say that's fine. But strictly speaking, all of the summary should be on display within your premises.
Okay.
The other part of the license, part A, is the nitty gritty of the license. So that not only then has who holds the license, not only sets out the licensable activities and the hours, but it also has things on there of the mandatory conditions in Annex 1. And then Annex 2 will set out any conditions which are consistent with the operating schedule. And then finally, there may be a section which has conditions which are attached after a hearing in Annex 3. And then the final annex, but again, not all local authorities are good at this. There should be a copy of the premises plan attached to it. So all of those 4 annexes to Part A are important, and it's important that you read all of them to make sure that, one, you can comply with the conditions, and also note that in relation to the plan which is attached to the premises license at the back, that everything is accurate. Because again, if your plan is wrong, then it's possible that the local authority will look to say, well, hang about, you're not carrying out licensable activities in accordance with your license. That's a criminal offence. So get it sorted, do an application, or we'll consider prosecuting.
Yeah, no, very, very wise. And I think it's essential if people haven't done it for a while, pick them up, read them, check all the
Absolutely.
details, especially as we were saying about some people may have applied for licenses decades ago and not made any changes. So, yeah, very, very good point to go through that at the moment.
Indeed, also, Chris, sorry,
Yeah,
just picking up on that, there are some operators, tenants, who may go into a premises, know that it's got a license, but actually not have the detail. They might have been given the summary when they've gone in, but have never seen the conditions. It's so important to read those conditions because, again, you're responsible for complying with them. If you don't comply with the conditions on your license, that is a criminal offence, which you can be fined and or imprisoned. So it's really
you could
serious.
sleepwalk. Yeah, you could sleepwalk into a bit of a disaster there just by not seeing the
Absolutely.
whole thing.
Yeah.
That's a really key point. In fact, just on the subject of getting into trouble, perhaps being threatened with a review or criminal prosecution, etc. I hesitate to say, are there any cheap steps to getting your license varied, or is there a kind of in your mind it's always going to cost you X to start doing variations to licenses, and if you've got to defend yourself, like you say, criminal or license review, that's many many thousands of pounds, possibly tens of
Mm.
thousands. So is there any cheap steps that people can use for reviewing their licenses, or not reviewing, sorry, making variations should they want to do something like hold weddings?
Okay. I think I'm going to come back to the point about reading the license. Some people think their license says one thing when indeed it says something different.
Yeah.
Um, I think that again, I'm bound to say this, you'll say, but I think having somebody who knows what they're doing and getting advice from them can be really, really helpful. Um, Simply because it may be, as I say, that there may be some things that you want to do, but you don't think you can. But actually, if you talk to someone who knows what they're talking about, they'll probably say, actually, no, you can do that as long as you do it this particular way.
Sure.
So that I think can be useful. Um, I'm never a great fan, I'm afraid, of asking a licensing authority whether you can do something, because unfortunately, not all of them know what you can and cannot do. Some are good, but not all of them are.
Yeah,
And
they're not equipped to give you advice,
no,
if
not
anything.
really.
No, no.
So minor variation is a cheaper process, quicker process. which enables you to do small changes. So if you were
So
doing
let's say you got
small
married,
change
yeah,
to the plan,
your maiden,
sorry,
say you got married, your maiden
yes,
name's changed. That's a minor variation, yeah?
you can change your name. You wouldn't need to do a formal variation application in relation to that. That should be
Fine.
fairly straightforward.
Great.
But if you want to change some of the conditions or tweak some of the wording on the conditions, then that might be able to be dealt with as a minor variation. Worthwhile in those circumstances saying to the licensing authority, or if it's like a CCTV condition, having a chat with the licensing police officer saying, look, this is what I want to do and this is why I want to do it. I was going to try and do this as a minor variation. Are you okay for me to do it as a minor variation, or are you going to put an objection in to this? That's worth having that conversation, because if they turn around to you and say, well, no, that's a full variation, then at least you're not going to go down the minor variation route, waste any time, put in an application fee and go through that whole process.
For nothing, yeah.
Other
Good.
than that, you're looking at a full variation, and that obviously is looking at the full application process, the full application fee to the local authority, notice in the newspaper, and then opening yourself up to objections, representations from people who are in the area who may wish to object to your application. I have to say, and again, I'm sure that there'll be a number of licensing consultants and solicitors who may say similar. Depending on the authority, there are some things that if you want to change your license, you might be advised to get a new license and not vary the one that you've got. And that is because some local authorities might take an opportunity, if they get some objections in, to do things to your license which you don't really want. And it's happened far too much. I've seen it happen far too many times, and had to deal with the fallout from that. So again, if it's a detailed change, a variation that you're looking for, and you think that you might have a few awkward neighbours who might want to cause difficulty, I would suggest approaching licensing consultant, licensing solicitor, and getting some, proper advice as to how
I
to
totally agree. I think there's an awful lot of people, perhaps in the pub trade, treat it a little bit as a hobby, as a bit of a side hustle. Let's use the modern phrase. Yeah, I mean, the license is the thing that literally touches the road. It's like the tires on a car. And if you lose that or muff it up, it's really going to be very painful, and it's going to lead to a lot of expense. And let's face it, even in a modest pub, people, are turning over hundreds of thousands of pounds. They've invested a lot of time, money, and effort. And the last thing you want to do is blow all of that just for trying to cut a corner. So brilliant timely advice there, Robert, on all that issue. On the subject of restrictions and requirements and that, it seems like a long time ago, but we had the pandemic. Remember that? that wonderful crushing event that swept across our nation and many others, 2020 to 21. The government of the day, the Tory government there, they brought in a number of relaxations. I think that's how we describe them. And these relaxations allowed pubs and bars to do certain things. And Robert, these things, they come to an end this year. Is that right?
So yes, they introduced a couple of things. I suppose the main ones that people will be familiar with are the off sales provisions and the pavement licenses. In relation to the off sales, the relaxation enabling all on sale premises, licensed premises within certain criteria to be able to do off sales, that came to an end on the 31st of March. So that is no longer available. However, if you were making use of them and you're suddenly realizing that you shouldn't be anymore, there was a change to the government guidance that was issued about that time, which said that if you wanted to make the off sales permanent for, enabling people to drink outside on a pavement license or whatever, that if there haven't been any problems with the operation, and with the use of an outside area, since these changes were introduced in the summer, I think, of 2020, then you could probably deal with it as a minor variation. We were talking about minor variations a few moments ago, and this, they've said you could do as a minor rather than having to treat it as a full-blown variation application.
Fair enough. No, that's understood. And again, it's crucial that people in pubs don't just bury their heads. They need to they need to start making these connections to people like yourself. I mean, we mentioned the Kent LVA. This is where you can learn knowledge, share
Yes.
knowledge. Undoubtedly, you can get a certain amount of stuff off social media. We understand that. We're all agile to that thing. Hence, we're using it today. But you can get erroneous, half-baked messages, and it is no substitute for actually speaking to people that have been there and walked the walk. I think, lastly, I wanted to chat to you about temporary events notices, and there are a number of pubs. Here we are, hitting summertime, weather's turning, people wanting to use their outdoor spaces, maybe have some kind of event on during the summer holidays, that they wouldn't normally hold, maybe even a weekday. What's the process, temporary events notices, and are there any different types of temporary event notices, and how should you use them?
Okay, cool. That's one of those short questions which I could go on for days, and no doubt at this stage people may almost be reaching for the on-off switch. I shan't go on for days. Temporary event notices are very helpful. They're meant to be a light touch. And are very useful. But having said that, there are limitations to them, and you need to be aware of the limitations in respect of the number of days that you can have and the number of temporary event notices you can have. So you can have 15 temporary event notices in a calendar year. So that's from the 1st of January through to the 31st of December. They can cover a maximum of 21 days. And there are limits on the number of days that each 10 can last for. So in essence, you couldn't have one for, and I can't, don't ask me to do it in hours, but in days, it's about 7 days. So,
Okay.
So they're very helpful. You need to give at least 10 working days notice. 10 working days is, you would have thought, is got a common approach to it, but there are some authorities that will treat it slightly differently. So in essence, when you're looking at 10 working days, it's safest to ignore the date that you put the temporary event notice in.
Okay.
Can be done online. Generally, I would suggest you do it online. It's much easier. So the date that you lodge it or serve it, discount that day, discount the day that you're doing the event, and make sure that there's 10 working days in between those two dates.
So bank holidays are a no-no. You can't count bank holidays, yeah?
But can't count bank holidays. Sometimes you'll get caught out on that.
Yeah.
So yes, you can't count bank holidays. Now, if it's a normal temporary event notice, I would always suggest giving as much notice as you can. So if you know that you're doing an event, if you know that now you're going to be doing some events in August, I would suggest that you get your temporary event notices together, put them in. And let the if you send them to the local authority digitally, then they will make sure that they go to the noise team. They'll make sure that they go to the police, and then they will have 3 days to make any objections or contact you and ask you about it. Find out whatever is going to be happening, whether there are any other measures that you're going to put in place, whether you'll agree to license conditions going on to the temporary event notice. So those conversations take place, and most of the time are positive and helpful, and can clarify what you're looking to do. So can be very, very useful. If the police or environmental health don't consider that you're going to be promoting the licensing objectives, they may put a representation in, and you may end up going to a hearing. Now, the other type of temporary event notice that you can give is one that's known as a late temporary event notice. Now, a late temporary event notice is basically one where you don't give those 10 working days notice, but you do give more than 5 working days notice. So something between 5 and 9 working days notice is given. The local authority can take it as a late temporary event notice. The difference, and there's a key difference between the two, is that on a late temporary event notice, if the police or the environmental health team, they put a representation in, then that's the end of it. You don't have a right to go to a hearing. You don't have a right to have a conversation with them and try and sort things out. As soon as they issue a representation, then the local authority is bound to issue what they call a counter notice, which is basically saying, even though you've given us the temporary event notice, you can't rely upon it because there's an objection to it. So wherever possible, always best to give sufficient notice, because that enables those conversations to take place if they need to take place with the authorities. And as I say, if you can't resolve things with them, then at least you've got the ability to put it in front of a licensing committee.
Yeah, well, wonderful. Thank you for that. And as you say, it's a huge subject. Potentially could go on for days talking about temporary events and the various case studies and mistakes that people have made.
Yes.
We may well come back to that. I mean, I think we've covered so much today. And Robert, thank you so much for coming on to the podcast and talking about these issues. I mean, we've got other things that hopefully we can come back and do at another time. We've got the CPN issues, which the community protection notices, is that right?
Yes.
That's a big one. So as I think we're agreed, that possibly needs something all of its own. And CPMs are loosely there to tackle antisocial behaviour, etc. And I think, there have been developments in licensing, noise abatement notices, etc., which have very much become more of a tool in this century than I think in any other period, and obviously are causing issues, and people are having to come up with strategies to deal with them. So I would love to have you back on, if that's all right with you, another time. And
love to come back. Thank you.
Maybe we can spend a couple of hours talking about TENS notices.
I'm sure that most people probably have a lot more interesting things to do.
We're in danger of a podcast like this turning into something like the Dull Man's Club or something.
Oh no!
But we mustn't forget the women that also work in licensing. That help people pass licensing courses up and down the country. Sarah Clover, a barrister at King's Chambers. I will give a shout to her, because she's one of the very early people I spoke to when we got PUBS Advisory Service going, and I know she's been doing a lot of great work there. So
very good. Yeah,
it's a small world, isn't it? I think
it is.
You all get to know each other quite well. So it's brilliant to meet you again, and thanks for coming on, and look forward to speaking to you again sometime.
No problem. Thank you.
Hello once again, this is Chris from PUBS Advisory Service. Thanks ever so much for listening to the podcast, and I really hope you enjoyed it. If you want to get in touch with the show, please use WhatsApp. You can contact us on 077 66 07 3815. That is 077 66 07 3815. You'll also find this number in the links and on our webpage, pubs.expert/podcast. Thanks again.